Hello, this is Matt on the Moon Lambo channel. Ladies and gentlemen, boys and girls, this is the one that we've been waiting for. The saga of the reconsideration of the reconsideration continues. You may recall that back in January, a judge in the SEC versus Ripple case said, hey, SEC, yes, you do indeed have to give over former SEC Director Bill Hinman's emails associated with the Ethereum free pass speech. Now, the SEC didn't take so kindly to that because my suspicion, anyway, is that there's exculpatory evidence and there are something that would tremendously harm their case. But they've been fighting against this order harder than anything else in the entire case, and by a long shot. They look so guilty and so desperate. There's something going on there. So they filed another document that said, hey, judge, okay, because mind you, when the judge said you must hand over the Bill Hinman documents, it's because the Ethereum free pass speech, it was just his personal opinion. That's what he said. That the judge agreed. The judge said, okay, so since it's just personal opinion, there's no claims of privilege to be had. SEC, you must hand over all of these internal documents. Well, they didn't like that. So they came up with a completely absurd proposition that, yes, it was his personal opinion, but it was also the official position, not of the SEC, but of the Division of Corporation Finance, which is what Bill Hinman was directing at the time, you see. So it's not the SEC, even though that division is the SEC, but setting that aside, they thought that this would allow them to make a privilege claim so that even though it's Bill Hinman's opinion, it's also the division's opinion, and therefore it's still privileged and you still can't have the documents, Ripple. They actually thought that argument would work. The judge said no and wasn't too happy with them. So that was already a reconsideration of the consideration. Now we have on top of that a reconsideration of the reconsideration because the SEC super duper extra doesn't like this. They claim now that this is so absurd that all of these emails associated with the Bill Hinman Ethereum free pass speech, they're actually protected under attorney-client privilege. I kid you not. So Bill Hinman's a client of his coworkers? That's effectively what they're claiming? Well, Ripple doesn't like that. It doesn't make any damn sense. And they filed their response. I got my hands on it late last night. And I have printed it up. You hear this? Got some dead trees up in my little Moon Lambo fingers. And I highlighted the parts that I found to be most interesting on this. And I'll tell you this, Ripple attorney Matthew Solomon just tears them to shreds. It's a sight to behold. You're absolutely going to love this. So go ahead and sit back, kick up your toesy wosies, get your popcorn popped. You can hit pause if you need to do those things first. I'll be here when you get back. But I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, before I dig into the parts that I highlighted on this page, I wanted to share with you perspective from 3 attorneys within the XRP community. I've got attorney Jeremy Hogan, attorney John Deaton, and attorney Fred Rispoli. And attorney Rispoli, you may recall, is the one that filed lawsuit against Jay Clayton and also Bill Hinman. And he since dismissed that, at least for now. He pulled the lawsuit back for now, but that's more of a strategic thing after he spoke with attorney John Deaton, but he has every intention of filing that at some unknown point in the future. It's a coming back. So we'll start with what attorney Jeremy Hogan had to say about this, and then we'll get into the specifics. He said, Solomon continues to amaze. That's Ripple's attorney, Matthew Solomon. Solomon continues to amaze. He takes the finding that the speech was Hinman's personal opinion and shoves it down their throats pretty hard. The SEC really messed that up. How can Hinman receive legal advice from SEC lawyers for a personal opinion? But Solomon also plays a veteran move in responding to the SEC and argues that only Hinman has the standing to even raise the privilege and not the SEC. It's good legal work to take an issue down to a basic premise. Is this even the proper party to object? Hence, King Solomon. All right, and then we've got this from attorney John Deaton. He wrote, the bottom line is that the SEC, reacting to Ripple's fair notice defense, rushed in the beginning to argue the Hinman speech was his personal opinion only, and not guidance from the SEC. If only his personal opinion, how could it be considered legal advice from the SEC? Well, that's a good question. How could it be legal? Well, it can't be. If anybody's got half a brain can see that. And of course, we don't know for sure how the judge is going to rule on this. It could take some weeks. And actually, I think the SEC may get to respond to this first. So it could be a few weeks and then a few weeks after that. So maybe you're looking at another month and a half or who knows. And then we'll get the judge's ruling on this. But I still don't see how anybody with half a brain, if you have at least half a brain, how you could not find this to be completely absurd. That the SEC, it's clear desperation. It's not logically cohesive what they're saying here. Attorney John Deaton also said this. Attached are documents added to cryptolaw.us, including excerpts of Hinman's deposition. Yeah, actually, let me make sure I give time to provide proper shout-out. I meant to do that a little bit earlier in the video. A shout-out to attorney James Filan, who shared this document, and also John Deaton's Crypto Law organization shared this document as well. So they're both really fantastic about sharing this news with the official public, and the public, the XRP community. And I appreciate it because in order to get these documents, you have to sign up with a service. I can't remember what it's called. Jeremy Hogan talked about this, so I'm just pulling from memory here. But there's a subscription service that you have to be a part of, and then it costs something like 10 cents per page to get the documents. And then they do that. They spend their own time and money on that, and then they share it with the community. So nothing but love and appreciation for these people who are doing this. So again, shout out to John Deaton's Crypto Law and also James Filan for doing that. So anyway, here's what John Deaton's tweet. Attached are documents added to cryptolaw.us, including excerpts of Hinman's deposition. It's blatantly obvious how he avoids telling the truth. He recalls nothing about the 58 drafts and accompanying comments regarding one of the most market-moving speeches in SEC history. Yeah, that's true. And as far as the exhibit, I'm not going to get into the exhibit, at least not. There are two exhibits, but not in this video anyway. One of them was part of Hinman's deposition, but Fred Rispoli had something to say about this. And he had a long thread, which was excellent. I'm not going to go through the whole thing just for the sake of time. It was great stuff, but I did want to highlight part of it, which reads as follows. First, reading a brief like this infuriates me because it crystallizes the absolute hypocrisy of the SEC. Someone posted just yesterday that SEC's Director of Enforcement was whining about defense lawyers stonewalling the SEC. And this is what the SEC does when it doesn't like the spotlight thrust upon itself? Pathetic. Second, we don't get much from the attached excerpted Hinman transcript, but we do get some more insight. There is zero doubt in my mind that Hinman has a big problem here. He doesn't remember anything from the dozens of edits he sent to dozens of people about one of the most significant speeches in the history of cryptocurrency by an SEC official acting in his personal capacity that moved a market by billions of dollars. So I'll just pause to note there. He's not going to have a good time if he ends up in court. I wouldn't think so anyway. There's a lot to answer for, and I would love to see his answer on whether or not he is aware that his firm, Simpson Thacher, was a member back then and today of the Enterprise Ethereum Alliance. I bet he's going to say no. So let's go ahead and dive into this thing now. And again, I just highlighted some select portions of this. There are 5 key points. The last one I'm not going to read through because basically it was just an assertion that if the SEC is going to claim any privilege over any aspects of any of these Hinman Ethereum Free Pass related emails, if the SEC is going to do that, then the judge should do an in-camera review of them, which just means in-person review, so that she should be aware of the information in them to make a decision on whether or not that information should actually be redacted or not. The first 4 points, though, were more on tearing the SEC to shreds. So let's go ahead and hop into this. Here, I can zoom out a little bit. This bad boy, it's super zoomed in. All right. So I'm going to start right with this section right here, and I'll try to remember to scroll down as I go through this for you guys, if you guys are looking at a screen out there. All right, to Judge Nepern. This is from Ripple's attorney, Matthew Solomon. This is really good stuff. You guys got your popcorn ready by now, right? All right, the court has ordered the SEC multiple times to produce documents related to the formulation of a speech that former Director of Corporation Finance William Hinman delivered in his personal capacity in June 2018. First, the SEC resisted, claiming the deliberative process privilege protected them from production. The court rejected that argument. Now, the SEC has doubled back to a theory it has not raised in several briefing rounds, that they are all protected attorney-client communications because Mr. Hinman shared drafts of the speech with other SEC staff, including some lawyers, for the primary purpose of seeking legal advice. Now, to anybody listening to this, you can see how ridiculous this is. And it's worth pointing out here, too. If this was the case, why didn't they just start with this and assert this first? Because all of the other rigmarole that we went through, all the points cited, the time wasted in the legal fees, it was all moot. None of it matters whatsoever if there's truly a attorney-client privilege. That you'd start with this first, because that would be the most obvious, if true. But instead, we went through all these other trivialities, this or that, and all the litigation, and it could not be more clear the SEC doesn't believe what they're arguing. These are bad people. What a bunch of freaking asshats. Now, moving on to their point number 1, which is the following. The SEC did not establish that Mr. Hinman communicated with SEC staff about his speech for the purpose of obtaining or providing legal advice. A communication is not made for, quote, the purpose of obtaining or providing legal advice, end quote, just because it vaguely addresses legal concepts. The predominant purpose of the communication must be to render or solicit legal advice. Further, advice from an attorney on non-legal matters, such as policy or messaging, is not privileged. When an attorney is consulted in a capacity other than as a lawyer, as, for example, a policy advisor, media expert, business consultant, banker, referee, or friend, that consultation is not privileged. In other words, there is a vital distinction between advice that can be rendered only by consulting the legal authorities and advice that can be given by a non-lawyer. So what they're getting at here is, even if you have attorney-client privilege to some degree, you can say things that wouldn't be protected on that because they have nothing to do with the legal concerns at hand. That's what they're saying there. Piece continues. The attorney-client privilege is triggered only by a client's request for legal as contrasted with business advice. The communications at issue fail this test because they were not made for the predominant purpose of obtaining legal advice. Rather, the purpose of Mr. Hinman circulating the draft was, in both his and the SEC's words, to, quote, discuss Mr. Hinman's thoughts with other commission employees as part of the commission's ongoing deliberations about whether offers and sales of ether constituted securities transactions, end quote. So already there, that's evidence of the true purpose of this communication, the fact that Bill Hinman was sharing drafts of his speech. It was not attorney-client privilege, as if he had done, and by the way, there's like what, I can't remember, there are 38 people, SEC employees on that list? Are they, so that's all privilege? Like what in the ever-loving hell? They're all his attorneys? But no, like this, again, the purpose was cited right there. It was to get feedback. They admitted as much already. This whole thing, there's no way this stands. But anyway, Solomon continues. Exhibit B, the Hinman deposition, testifying that he circulated the draft of the speech to get reactions to its content. That's different than legal advice, folks. Reactions. Mr. Hinman planned to give a speech at a private event where he would express his personal views on cryptocurrency regulation, and, in preparing that speech, he sought to discuss his thoughts with others at the SEC interested in that topic. All right, let's move on to number 2. I'm actually kind of glad this thing was only 5 pages. Some of these things are like dozens of pages. It takes me forever to read the whole thing. And the thing is, like, I appreciate it all and all the effort that went into it, but most of these documents is dry, so like you have to go through like sometimes dozens of pages and pick out the actually interesting stuff here. Anyway, so point number 2, labeled as the following. Mr. Hinman did not have an attorney-client relationship with SEC lawyers in his personal capacity. Now, this should be abundantly clear. Or, because even if he did, did he just get free SEC lawyer labor on the account of the taxpayer's dime, or did he pay them? No, of course he didn't pay them. But it's stupid. So anyway, here's what Mr. Solomon argues. The lack of merit in the SEC's position is reinforced by the fact that Mr. Hinman delivered the speech in his personal capacity, not on behalf of the SEC. A claim of attorney-client privilege must first rest on an attorney-client relationship between the parties to the communication. So let me just pause. Like, I'm not a lawyer. I knew that. The SEC knows that. This is the most absurd, absolutely most absurd thing that they could be arguing right now, but they're actually arguing this. And then Solomon writes, holding attorney-client privilege applies only to communications between a client and an attorney. Groundbreaking stuffer. It's sad that Mr. Solomon actually has to point this out. It's only between a client and an attorney. Here, the court has already found it settled that Mr. Hinman's speech was given in his personal capacity and reflected his own opinion. The SEC may not now argue otherwise because it disagrees with the court's conclusion. Bam. Absolutely. Bringing the fire per usual. Then there was the next bullet point here on the next page, which is titled, the disclosure of the communications would not reveal SEC confidences. And it reads as follows. Here's the relevant portion that I want to get started about here, starting about there anyway. The SEC bears the burden of proving the communications reflected confidential information in the first place. The SEC's failure to articulate the basis for the confidentiality of these documents is unsurprising. What confidential information concerning the SEC could exist in comments to a speech conveying Mr. Hinman's personal views? Exactly. What the hell could be privileged here anyway? What's supposed to be confidential if indeed it is just a personal opinion from Billy Boy Hinman? That's a tough hill to climb. And I don't think the SEC is doing it successfully at all. Point number 4. The SEC lacks standing to assert the attorney-client privilege on behalf of Mr. Hinman. Even if, and I love this here, this is so clear, even if the SEC was right that Mr. Hinman's communications were privileged, and it is not, the SEC offers no basis for concluding that the privilege in question is the SEC's privilege. Rather, to the extent that Mr. Hinman was receiving legal advice in his personal capacity, it would be Mr. Hinman's privilege to assert. So pause to think about this. It's the asshat attorneys at the SEC, and they have to know better than this. They're the attorneys. They should know how the rule of law works, right? They're claiming privilege here on behalf of Bill Hinman. They have no power or privilege to do such a thing. It is Bill Hinman who would have to assert the privilege here. They'd have to drag him back into this. The SEC has no right to claim privilege. It's not their privilege, it's Bill Hinman's privilege. And then Mr. Solomon writes, it is nonsensical to suggest that Mr. Hinman was seeking personal legal advice from his colleagues at the SEC regarding the application of the securities laws to certain digital assets. Either way, these documents are not privileged and cannot be withheld from defendants. So let's pause to think about that. If this is actual legal advice, think about the idea of this. Bill Hinman, running the Division of Corporation Finance, he's asking for legal advice on specific cryptocurrencies? As he's at the top of the Division of Corporation Finance, that he can give a speech about it? It's absurd on its face. He needs the advice. As if he's not part of the team. He's now like separate from the team. He's still employed by the SEC, but he's like somehow separated, and he needs the adults in the room to tell him the things about the cryptocurrencies so that he can speak publicly about it. Oh my God, this is completely ridiculous. Who's going to fall for this? I can't imagine the judge falling for this. Really grinds my gears, folks. But that's it for this latest Moon Lambo Hot Jam. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.